Welcome to the latest episode of On One Foot, the virtual learning series that features different Jewish faculty members from our local universities, which spotlights the incredible Jewish intellectual talent we have here in Memphis. We launched this program during the pandemic as a way to learn together and keep connected, but the programs proved to be so popular both live and in a recording afterwards on our YouTube channel that now we're into season 4. Our guest speakers are encouraged to discuss topics related to their academic field, viewed through a Jewish lens, and share about their own Jewish journey. Our guest today is Professor Daniel Kiel, a professor of law at University of Memphis. He's been a member of their faculty since 2008. He teaches property law, constitutional law, and education and civil rights, and was awarded the university's Distinguished Teaching Award in 2017. His scholarly work centers on inequality in the education system, particularly along the lines of race, which is what I believe he's going to discuss with us today. So I'm obviously not Sophie. She's on maternity leave. I'm Matt Timberlake, Director of Communications for JCP, and I will now hand it over to Daniel.
Thank you, Matt. Thank you, everybody, for being here. And thank you to and congratulations to Sophie in absentia. It is great to be here, and I was asked to share a little bit of my, sort of research and, the things that I'm working on right this instant. And so, though perhaps everyone was expecting me to talk about race and inequality in Memphis, which I would, of course, be happy to talk about, I actually have a different topic, and it is a topic that I have been working on for some period of time, and it's not as directly connected to sort of my Jewish journey and my Jewish identity, but it is, I think, something that is very relevant in the American context in which we sit right now, and that is looking at the impact of transitions on the Supreme Court of the United States. And by transitions, what I'm talking about are those wildly unpredictable moments when one Supreme Court justice is to be replaced by a different Supreme Court justice. And so, I don't know how participatory this group is willing to be or wanting to be, but I just wanted to sort of start with a question. How many Supreme Court justices do you think there have been in American history? You can either unmute and talk or put it in the chat. Don't wait on me to call on you.
200.
So we've got 200. As one, over 100, so somewhere between 100 and 200 I'm seeing. Don't just look it up on Wikipedia. I know that you guys can find the answer very, very easily. It is between, you guys are right, it is between 100 and 200. It is 116. There have been 116 Supreme Court justices. And that doesn't actually mean that there have been 116 transitions on the Supreme Court, because for a variety of reasons, and the most obvious one is when the first justices were appointed back by George Washington, there was no Supreme Court transition. There was just a new Supreme Court. In addition, there have been a couple of moments in American history in which the size of the Supreme Court has shifted, has changed before it got sort of ultimately to where we are now with 9. And so in those moments, there weren't necessarily, so not all 116, there hasn't been 116 transitions is what I'm trying to say. But there have been 116 justices. And I'm drawn to this particular topic for a variety of reasons. But one thing that I think is really fascinating about it is that it is so unpredictable. It is so irregular. And so, for example, in 1971, 2 justices took their seats on the same day. So Richard Nixon had appointed 2 justices, and they had been confirmed days apart, and they were invested and took the bench on the exact same day in 1971. So we had one moment in which 2 justices were arriving. So a transition of 2 at one time. But then on the other end of the spectrum, from 1994 to 2005, there were no transitions on the court. The court was completely stable, at least in terms of the makeup of the people on it, for 11 years, sort of the longest period in modern Supreme Court history with no change, and perhaps, I think, I don't want to say it for sure, the longest in Supreme Court history at all, 11 years with no transitions on the court. But a court transition happens roughly every 2 to 3 years, and but they're unpredictable and they're irregular, and they don't all mean the same thing. And so what my research project has been over the maybe last 5 years is trying to figure out a way in which we can quantify how impactful Supreme Court transitions are. And then I'm big into, I'm not usually big into rankings, but I'd like to be able to identify which ones have been the most significant. So the sort of task for my talk today is to sort of walk through how I've done that evaluation and identify a couple of the more important Supreme Court transitions in what I'm calling the modern Supreme Court era, which begins in 1953. So approximately the last 70 years. And so that's the goal. So hopefully that's okay. I don't know if that's what you guys signed up for, but that is, if the purpose is to share, sort of potentially interesting research, then I'm hoping I fit the bill here. And I'd like to leave some space after I talk for a little bit to discuss and hear your thoughts on these various things. So I have some slides, and some of the slides have some numbers, and that is a way in which I've attempted to sort of quantify the transitions, the sort of magnitude of the transitions, but don't feel like you need in any way to sort of follow the details of the numbers that I'm going to put up on the screen. So I just want to start, the unpredictability of this is what draws me to the topic, but what really makes it, I think, even more gray is that the United States Constitution says almost nothing about this topic, about Supreme Court generally and about Supreme Court transitions more specifically. And so just going to a little bit of background information. So here is the first part of Article 3 of the U.S. Constitution, and this is where the court is created. And this is pretty much all we have in terms of the makeup of the Supreme Court. So the judicial power of the United States shall be vested in one Supreme Court. So there is a Supreme Court, according to the Constitution, that exists, and in such inferior courts as the Congress may from time to time ordain and establish. We're going to skip over that for now. The judges, both of the Supreme and inferior courts, so this sentence is letting us know that the Constitution is imagining that there will be Supreme Court judges, shall hold their offices during good behavior. And this is the sort of lifetime appointment part of the Supreme Court justice's job, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So what we know from the Constitution about Supreme Court justices is that there is a Supreme Court, there are judges, and they serve for life, and they will get paid, and they can't have their pay diminished. That's pretty much what we know. In other parts of the Constitution, we know things like the president will be assigned with the responsibility of appointing these people, and that the Senate will have some role in consenting, advising and consenting, and confirming the justices to the court. But that's pretty much all we know. And so the rules have been developed and written over time. They don't come from the Constitution, even the rule or the current state of things in which we have 9 Supreme Court justices. Okay, so we are operating in a space that has very little constraints when we're talking about the Supreme Court. and very little predictability in terms of turnover as a result of the lifetime appointments. Because basically, unless a justice decides to retire or a justice decides while in office, then there are no transitions, right? The transitions occur either when a justice dies unpredictably or when a justice chooses to retire. So those are when the transitions happen. There have been there in this era, 1953 to today, there was one instance in which there was a justice who neither retired voluntarily nor died, and that is a justice that is very much connected to our community here, and that is Justice Fortas. So Justice Fortas, of course, a Memphian, a Jewish Memphian who served on the court and resigned from office during the Nixon administration. Yeah, Bruce, I see you got your hand up.
Yeah, sorry. I in reading Good Behavior, if I were one of the founding grandfathers, I would not interpret that to say that means a lifetime appointment. I would mean, without scandal, without wrongdoing. How did that get to be interpreted as lifetime?
So before I respond to that, there is, of course, an implication there that the justices could be removed in times of bad behavior. And that has been attempted, but never successfully with regard to Supreme Court justices. So Supreme Court justices can be impeached. And in fact, during the Jefferson administration, one Supreme Court justice was impeached, but wasn't convicted, and so stayed in office. There have been lower federal court judges that have been impeached and convicted and removed from office, but not at the Supreme Court level. Justice Fortas is an interesting case. There was some threat that he might have ultimately been impeached, but under sort of the political pressure of the moment, he resigned. Didn't retire, he resigned. So whereas many justices have retired voluntarily over this time period, Justice Fortas was sort of pressured into resignation. I can talk a little bit more about that particular moment if people would like, because it does connect to the Jewish Memphis very much so. But the answer to your question is that is how it has been interpreted from the beginning, right? So from the outset, that from that moment of Jefferson's during the Jefferson administration, the attempted impeachment of Justice Chase, there was some discussion around that time about, well, when do they stop serving? And the provision that I just showed has been interpreted that they stop serving when they are no longer alive.
And of course, the body that would decide the interpretation is the Supreme Court itself. So
yes and no. Yes and no. There are some. There is some room for Congress to adjust things. So this is a little outside the scope of my time period, but in the 1930s, President Franklin Roosevelt wanted to change the makeup of the court, but felt constrained, could not just fire Supreme Court justices. And so it is possible to change the way in which the court is structured so that there aren't just 9. And so his proposal was to increase the size of the court. So once a justice reached, I think in his proposal, it was a justice reached the age of 70, they would not be removed, but a new justice would be appointed. And so the court would grow. It wouldn't have a fixed size. So at the time, I believe there were 4 justices that were over the age of 70. And if that had been passed in Congress and signed by President Roosevelt, then there would have been 4 new justices to be appointed, not replacing the 4 that were over 70, but sitting alongside them so that there would, at least for that period, be 13 justices. And so it's not entirely with, yes, maybe on the lifetime appointments, that's something that the court would interpret, but it's not outside the authority of the other branches to intervene in some way on this front. So what I have worked to try to do is figure out a way in which I can evaluate which transitions have been the most impactful transitions. And the word impactful is the word that I'm going to keep coming back to, because there have been many historic moments in the Supreme Court and some near misses that ended up not being impactful, though they might have been. But I'm focusing in on the ones that have had the largest impact. And in order to do that, I have identified these two kinds of variables or characteristics to try to figure out which ones have mattered the most. And so one of them, this one over on this side, is to look at the difference ideologically, jurisprudentially, the way that they approach cases between the outgoing justice and the incoming justice, because every transition has, a few variables that are mattering. Who is the outgoing justice? Who is the incoming justice? Who is the appointing president? And what is the makeup of the Senate at the time, of the confirmation hearings? So one way to do it is to focus just on the two justices and how different are they from one another. But I'm going to walk through a little bit why I think that's not entirely a complete view. And so I've added on, in addition, the way in which the transition seems to be likely to affect outcomes of cases. And luckily, I'm looking backwards. And so I can see the trends that occur. And, so things that there are situations where it seems like it's going to be a significant impact on the outcome of cases, and the facts that have followed haven't proved to be impactful in any way, or in a significant way. And so those are the two sort of frames in which I'm approaching this project of trying to figure out which are the most impactful transitions. And on the first part, comparing the outgoing and incoming justices, there's three ways in which I've looked at this. I've looked at differences in the party of the appointing president, because though you all, some of you may disagree that, there are Republican judges and Democrat judges, et cetera, right? I think that people increasingly are seeing that as the way in which Supreme Court justices operate. There is not party affiliation in the same way as there is in the Congress on the Supreme Court. And so, but the party of the appointing president is out there, and is something that is a way in which you might judge the difference between two justices. And we'll talk about that in just a second. Second, there are ways, and I won't sort of bore you with, because quite frankly, I don't wholly understand it. There are ways in which we can quantify the ideological position of each justice in each term. And so people who are much more able with numbers to do this kind of work have done it. And I'm using a lot of their data to support the kinds of work that I'm doing. And so you can judge either the short-term ideological difference. So like, what was the difference between the outgoing justice on his or her last term and the incoming justice on his or her first term? Like, how did they differ ideologically? Or what about averages over time? Like yes, maybe in the short term, there might've been a big difference, but if we look at the sort of broad career of the outgoing justice and the broad career of the incoming justice, what's the difference? What's the difference on that front? So here is where some of the charts are going to start showing up. And there will not be a quiz, so don't feel like you need to pay any particular attention to this, but these are the transitions that have occurred since 1953, in which the appointing party of the president of the outgoing justice is different than the appointing party of the president of the incoming justice. And I think this is a relevant topic or a relevant metric because justices know who the president is when they resign or when they retire. And so it is the case. The reason why there have been 27 transitions since 1953. The reason why this list is somewhat short is because justices know who the president is, and justices are aware and on some level want to control who their successor is going to be. So most of the time when we see significant transitions, it is somewhat involuntary, right? The justice that's retiring or leaving or passing away is doing so at a time where the president that's going to appoint their replacement, they might not see eye to eye. Those are going to be situations where there's the most significant impact. So, the sort of most salient perhaps in our minds right now is the 2020 replacement of Justice Ginsburg with Justice Barrett. Justice Ginsburg, of course, having been appointed by a Democrat, Bill Clinton, and Justice Barrett having been appointed by a Republican, Donald Trump. And so I'm going to talk a little bit more about that particular moment because it sort of is what guides and triggered, in fact, this particular research. So there have been these instances, but sometimes it's a little misleading. So I'm going to look at this particular one here. Let me see if I can find it. Yes. So in 1975, William Douglas was replaced by John Paul Stevens. And William Douglas had been appointed by a Democrat, Franklin Roosevelt, and John Paul Stevens was being appointed by Gerald Ford, a Republican. And while at first blush that might appear to be, a switch in terms of the appointing president, over his career, Justice Stevens ended up being one of the most liberal justices on the court. And so while this picks up as a possible switch from Douglas to Stevens, it ends up not being as impactful over time because of how Stevens ultimately performs on the bench. So let me stop and talk for a second. That's just looking at the appointing president. In addition, I mentioned that we might also look at the average scores, average ideology of each justices on either side of a transition. And so I've done that as well. And again, disclaiming that I understand the statistical work that was done, that goes into this, I wanted to sort of note that there's two researchers, Martin and Quinn, that have, and I'm forgetting their first names, so my apologies, but they have developed what's called a Martin-Quinn score, which is statistical representation of the court ideologically. And negative numbers sort of trend what we would call liberal, and positive numbers trend what we would call conservative. And so before sort of, I want to sort of be somewhat realistic about what these represent. The vast majority of cases that the Supreme Court is asked to hear, the Supreme Court does not hear. So they are given thousands of requests to hear cases, and they hear about 100 cases a year. So very few cases are accepted by the court. Among those cases, we hear a lot about 5-4 cases or maybe 6-3 cases that are what we would call closely divided. But the vast majority of the 100 cases that the court hears are not 5-4 and 6-3 cases. In fact, they're 7-2, 8-1, and 9-0 cases. And so while I think that there is an impression, and those 5-4 cases really do matter, right? Those are really important cases. Sometimes it can be a little misleading to separate the court out as, these justices are liberal and these justices are conservative, because most of the time, 7 of the justices are agreeing on something, 7, 8, or 9. And so I just want to sort of put that out there that What I'm talking about are a small subset of closely divided cases, which is a small subset of all of the cases that the court could be hearing, which, you know, so it's a somewhat small sample size, I guess, what I'm trying to disclaim. And so, you know, I sort of got the numbers from Martin and Quinn, and I've sort of figured out the circumstances in which the ideological difference in the short term between the incoming and outgoing justice was most significant. And what I'm going to share is the top 10. First, I'm going to share the short term, year to year. And then second, I'm going to share the long term, their justices' averages over time. And I just want to highlight a couple. So I mentioned that, so this is the short term. I mentioned that William Douglas to John Paul Stevens transition. And I said, oh, that one might not have been as significant as it seemed, because Justice Stevens ended up being quite liberal over time. But in the short term, he was not. He, you know, if 0 is sort of not ideological either conservatively or liberally, Justice Stevens is at a 0.083. So very close to right down the middle. And over time, he will end up being in the negatives, but in his first term, he was somewhat not. And Justice William Douglas was by far the most liberal justice in his career, and this term in particular, particularly liberal. And so this appears to be a massively impactful transition. But I've already told you, this transition actually ends up not being particularly impactful over time, even though this measure suggests that it might be. Others to note on here, we have, I'll just mention it because it keeps coming up and it is relevant to Jewish Memphis. Justice Fortas being forced out essentially in 1970 and replaced with Harry Blackmun ends up making a pretty significant year-to-year difference between those two justices. And then one that we're going to see come up a few times here, or I'll just highlight the two that we're going to see come up a few times here, are 1991 Thurgood Marshall being replaced by Clarence Thomas. Thurgood Marshall being a very liberal justice, and even in his first term, Justice Thomas being tilting pretty heavily in the conservative direction. And so that creates a pretty significant gap even in that first year. And then the other one that I'm going to repeatedly come back to is when Earl Warren, who you all may know as the sort of leader of the court in the 1950s and 60s, is replaced at the end of the 60s by Warren Burger as Chief Justice. That is a significant transition as well. So this first slide is the differences short term. The differences long term are here, and you see some of the same ones. Again, you're seeing Marshall and Thomas here now, the top, and you're seeing Earl Warren to Warren Burger in the number 3 position. But note that you're not seeing that William Douglas to John Paul Stevens transition at all. Oh, no, yes, you are. I'm sorry. You're still seeing the William Douglas to John Paul Stevens. I'm not going to undercut it yet in there. And that has much more to do with William Douglas being so liberal. You can see here that Justice Stevens, on average, ends up being negative and in a liberal space as well. So let me pause here and see if there are any questions or anything, or if people are finding this interesting.
One question I have is about the relative age. In other words, are we trading a 60-year-old for a 60-year-old? Or it seems that, particularly with Trump's appointees, he's proposed much younger justices who are going to have, theoretically at least, a much longer impact on the court.
I think it's a great point. And it's probably something worth adding in to this analysis. Tenure, you know, like either what the tenure ended up being, or what, you know, you can judge age you can use age as a variable, but what really, Charlie, you're pointing out is that it depends on how long the justice ends up serving, right? So a justice who is appointed by John F. Kennedy, but is forced to resign in 1970, might have been pretty impactful, but only served for 6 or 7 years, and so that's going to undercut the ultimate impact of that particular justice. So looking at it, not just the averages, but how long the justices serve would be something good to throw in. And one of the things that I talk about later, or that I'll bring up later, incorporates that a little bit, but not exactly the way that you're raising it. But it's definitely the case that justices have trended younger, and that their tenures have trended longer. That's maybe just a function of the world in which we live and the lifespan in which Americans are typically living. Yep. Francine, I see you talking, but you're muted.
I mean, I'm on mute. No, I'm not on mute.
No, now you're good.
Okay. I said I'm going to show my stupidity here, but I can't unless I'm looking at the chart wrong. So when a justice is coming out and was appointed by a Democratic president, let's say, and then they're coming in being appointed anew by a new president, it looks like on the chart the president is always opposite parties. Does that just work out, or am I looking at that?
No, you are looking at a chart that is selected to only include those instances. So, for example, you didn't see Justice Ketanji Brown Jackson on that chart because she was recently appointed by Joe Biden, a Democrat, and she was replacing Stephen Breyer, who was appointed by Bill Clinton, a Democrat. And so I
just thought, how could that be? It just happens to work out. Okay.
Yeah, it's less than half the time the appointing president of the incoming justice is different than the appointing president of the outgoing justice. So I identified the ones where it was different. And so, yes, everything you saw on that chart, it was always different.
Thank you.
Mm-hmm. How was that, Ham? Yep. You're muted also.
How about now? Sorry about that. You mentioned the trend of justices being appointed younger and serving for longer periods of time. If you go back in the years that you've studied, have there been many instances of judges who resigned and it was a surprise due, to the relatively maybe younger age at which they resigned?
The one that I think of Justice Fortas, I will talk about it a little bit because that's a involuntary resignation. And so that's one where he definitely seemed to have a longer career ahead of him. And I'll come back to that in a second. David Souter retired somewhat recently during the Obama administration. And I think some people were a little surprised that he retired when he did. He's still, active and out there, and he's doesn't have any sort of health problems. But he retired, I think, what people would call early, or surprisingly early. But he retired at a time when he knew that the president that would appoint his replacement was, I don't want to be sort of crass and political about it, but was going to replace him with someone who would share his ideology, his values. And so I can't think of any instance in which a justice resigned at a young age or younger age when the opposite was true. There have been, so in the first George Bush era, the two most liberal justices on the court, William Brennan and Thurgood Marshall, both resigned during the first George Bush presidency. And neither of them was ideologically close to President Bush. And so, but both were in poor health. And so they didn't resign because they were just tired of being justices. They resigned because, you know, at least in Justice Marshall's case, it was, you know, the first Gulf War was happening, the Cold War, you know, the Berlin Wall was down, and like President Bush seemed like he was going to win a second term, and Justice Marshall might have calculated like, I'm not feeling well, I'm going to get out now. But there have been other surprisingly somewhat short instances that where a justice doesn't serve as long as is anticipated. I'm forgetting his name, but there was one in appointed by John F. Kennedy who served a very short period of time. Goldberg, I think, is that one. Y'all can look that up further. But let me talk about Justice Fortas because it keeps coming up, and we've got a Jewish Memphis crowd. So Justice Fortas is at the end of the Lyndon Johnson presidency. Earl Warren had been the Chief Justice of the Supreme Court since 1953 or 1954, and he was ready to sort of move on. But the politics in 1968 were such that Warren was concerned that if he resigned, you know, if he waited till after the presidential election of 1968, that he would be replaced by Richard Nixon and by someone that Chief Justice Warren thought would not share his values. So it's kind of the opposite situation. And so he goes to President Johnson. He says, I'm thinking about resigning. And here, I'd like to do it now, early, so that you can pick my replacement. And we don't have to wait for the election results of the 1968 presidential election. And President Johnson's plan is to elevate Justice Fortas from Associate Justice to Chief Justice, to replace Chief Justice Warren, and then also then appoint someone to replace Justice Fortas's position. Is that making sense? And so it's this attempt by President Johnson to sort of recapture and ensure that the Chief Justiceship remains in, you know, for lack of a better way of describing it, a liberal justice's hands. And the result of that is that there is a concerted investigation into the financial dealings of Justice Fortas. And there were some contributions that he had made that ultimately didn't end up being fraudulent or illicit in any way, but smelled that way at the time in the early days of the investigation. And all of that work was done in order to prevent his elevation to being Chief Justice. And so ultimately it caused enough friction that it led to the delay of the replacement of Chief Justice Warren. And the election happened, and Richard Nixon won the election. And then Richard Nixon appointed Warren Burger to replace Chief Justice Warren, who had already announced his retirement. And so, so that all happened. And I think I've already highlighted that the Earl Warren to Warren Burger transition is one of the most significant. And it's because not just of who was replaced, Earl Warren being sort of the leader of the court's most progressive era in the 50s and 60s. But it's also about who came on board, and Chief Justice Burger is the sort of beginning point. Beginning with Chief Justice Burger, there were 9 consecutive justices appointed by Republican presidents. And so for those who are sort of more interested in the broader shift to conservatism on the court, it begins there at that particular moment in 1969 with Chief Justice Burger. on to the Fortas part. So because of this investigation, he was not elevated to be Chief Justice, but he was still an Associate Justice into the Nixon administration. But the sort of high profile nature of the investigation really damaged his reputation in such a way that he was not forced, but ultimately chose to resign, which created another opening for President Nixon. And ultimately, Harry Blackmun is the one who is appointed and confirmed to replace Justice Fortas. But I'm getting a little ahead of where I wanted to be, but I'll just note, in the first 3 years of the Nixon presidency, he appointed 4 justices. And so the Warren era ends with this kind of screeching halt in the early 1970s in the court. What is still, I think, a tipping towards conservatism and more conservative viewpoints begins in that 3-year window, which includes Burger for Warren, but also the Fortas resignation. And for those of you who don't know, Fortas, was a Jewish Memphian, but also a graduate of Rhodes, and very, very significant Memphis connections. I see the question in there. I have no idea what a Supreme Court justice makes, but I will look into it maybe. Okay, so a couple of other things. So I've talked about the difference among the justice incoming and outgoing, but I think what really matters is whether or not the outcomes of cases change. And so I want to, I keep talking about that William Douglas and John Paul Stevens 1975 transition. And so I want to just sort of note this. So this is a lot of numbers, I know, but I want to just sort of walk through what you guys are looking at. So these are the 9 justices that are on the court before William Douglas retires. And these are the 9 justices that are on the court after William Douglas retires. And here you can see Justice Stevens is on and Justice Douglas is off, okay? And so this is 9. It takes 5 votes to win any case. And so they are organized here by their Martin Quinn score for that particular term. And so you can see Justice Douglas is kind of off the charts in terms of on the liberal end. And then the other end, you have Justice Rehnquist, who is the newest member of the court at that time. And he is the most conservative. But so to win a case, you've got to get 5 of these people involved. And so when I say that the transition from Douglas to Stevens is not impactful, I'm hoping that this graphic helps demonstrate why. The makeup of the court was such that simply replacing Douglas with even someone who was significantly more conservative than Douglas didn't actually change the makeup of the court, right? So if we look below this line, Stewart, White, Blackmun, Powell, Burger, Rehnquist, that's 6 justices that are unchanged, no matter whether Douglas is there or Stevens is there. And those 6 can, do what they want, essentially, or the 5 can do what they want from White down, or any combination of these 6. They don't need Justice Stevens, and they didn't need Justice Douglas. Or looking at it the flip way, if Brennan, Marshall, and Potter Stewart can get Justice White on board, then they would have had 5 before Douglas left, and they will have 5 with Justice Stevens as well. Okay, this is very rough, and it doesn't really explain any particular case, but I'm trying to demonstrate that, we need the change to not only affect the one of the 9 seats, but to actually have an impact on the median of the court. So before Stevens comes on, Justice White is the midpoint of the court. After, Justice White is still the midpoint of the court. He's what we might call the swing justice on this particular court. So another way in which we might evaluate which transitions are most impactful is by looking at the moments where the swing justice changes as a result of the transition. And so these are the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 times that the median justice or swing justice changes as a result of a transition. And so, you know, you see some of the ones that I've been highlighting. Here's Thomas for Marshall again. Here's Burger for Warren. Again, sometimes it's the swing justice that is leaving the court. And so obviously there's going to be a new swing justice. That was the case for Justice Anthony Kennedy in 2018 when Brett Kavanaugh came on the court. Other times it's a swing justice that's arriving. So when David Souter was appointed in 1990, he came onto the court as the median justice, as the swing justice. And so that was, those are significant moments. But I wanted to note that what matters, and this is kind of going to Charlie's point as well, is not just that there's a new swing justice, but that new swing justice remains, right? That it stays over time. It's not just that there's a new swing justice for 1 year. It's that it actually fundamentally shifts the balance of the court. And so in these 3 instances, and these are kind of 3 or 4 instances, what is shepherded in is not just a new median justice, a new swing justice. So Byron White becomes the swing justice in 1969 and remains the swing justice until 1991. Not every year in those 22 years, but most every year in those 22 years, Byron White is the swing justice. So Burger creates a new court with a new center. So too with Thomas for Marshall in 1991, Sandra Day O'Connor becomes the swing justice. And from 1991 until 2018, a period of 27 years, either Sandra Day O'Connor or Anthony Kennedy is the swing justice every year. So they are the new center, and they are more conservative than Justice White had been. And so it signals that the court has made a jump with that replacement of Thurgood Marshall with Clarence Thomas that endures for 27 years and really up until today. So first, 1969, Justice White becomes the swing justice. And then 22 years later, it's O'Connor and Kennedy that become the swing justice, both signaling a conservative shift. And then I've got this one in orange because it's a little more ambiguous. What's, partially because we're just a few years out. But when Justice Kennedy was replaced by Justice Kavanaugh, John Roberts became the median justice. He was the median justice for several years, but stopped being the median justice in 2021 the 2020-21 term when after Amy Barrett was appointed. So I'm trying to be cognizant of time here, and I want to sort of just make a couple of highlights. So maybe y'all have been waiting the whole time. Which is the most impactful? I've already kind of given it away. The 2 that I think are the most impactful, but I did want to note a couple of other ways in which you might judge impact. And one is to look at moments of historic appointments. So Thurgood Marshall, the first Black justice appointed in 1967, is obviously a significant moment in Supreme Court history. So too with Sandra Day O'Connor in 1981, the first female justice appointed. Antonin Scalia, this always surprises me, the first Italian-American justice appointed not until 1986. And Sonia Sotomayor, the first Latina to be appointed to the Supreme Court in 2009. And of course, most recently, the first Black woman, Ketanji Brown Jackson, just recently, this Monday, 4 days ago, sat with the justices for her first session hearing oral arguments. In addition, we might look at contentious confirmations. Confirmations in the last probably 35 years have been fundamentally different than they were before that. And they have become more contentious, but these are four that are probably worth noting. Blackmun and Kennedy, I've got an asterisk because they were not contentious for either Blackmun or Kennedy, but both Blackmun and Kennedy were actually the third choices for the court. So there was a nominee who was either withdrew or was rejected. Like in the Kennedy case, there was one nominee, Robert Bork, who was rejected, another nominee by the Senate, another nominee who withdrew, and Kennedy was the third choice and sailed through. So it was a contentious confirmation. And then maybe we're more familiar with the confirmations of Clarence Thomas and Brett Kavanaugh, both of which were clouded with allegations of either sexual harassment or sexual assault. And so those are worth noting because contentiousness suggests that it was an important particular moment. I've already talked about the four Nixon appointees as the sort of a moment that when taken cumulatively is really a screeching halt. But I have to mention the 2016 and 2020 situations with Justice Scalia dying in 2016 during the final year of Barack Obama's presidency, and Justice Ginsburg dying in 2020 during the final year of Donald Trump's presidency. And, you know, perhaps this is fresh in minds, but the argument was made in 2016 that was too late in a presidency to have a Supreme Court confirmation hearing, and that the election should in fact decide who the next Supreme Court justice would be. And the Republican Senate held out despite the fact that there was a potentially really impactful transition if Obama's nominee, Merrick Garland, had been confirmed to replace Scalia. That would have been a significant shift, the first real major shift in the court in probably 25 years. But that didn't happen. And instead, after the election, Donald Trump appointed someone to replace Scalia, who maintained the sort of balance at the moment. And then, of course, in 2020, the opposite occurred, right? So Justice Ginsburg passed away a month before the election and was ultimately replaced in that short time period by Amy Coney Barrett, which creates the sort of increase in the conservative tilt of the court, so that it is probably a 6-3 court now, and a 6-3 court that, you know, for those of you who pay any attention to the court, the most sort of, I don't know, famous, infamous, noteworthy development of that court has been the reversal of Roe versus Wade this past summer, a project that was that predated even Warren Burger, right? People think Roe versus Wade was a Warren court decision. It was not. It came after Earl Warren had already resigned, but a long-standing goal of the conservative legal movement accomplished just this past summer, largely as a result of Amy Coney Barrett's replacement of Ruth Bader Ginsburg. So I've already said it, the two that I think are the most important, and I'm out of time to sort of go into much detail on those two, are 1969, replacing Earl Warren with Warren Burger, and 1991, replacing Thurgood Marshall with Clarence Thomas. And I will offer a totally shameless plug. All of this should lead you to, in spring of 2023, purchase the book, The Transition, Interpreting Justice from Thurgood Marshall to Clarence Thomas, that I have been working on, and that is sort of adjacent to this broader research. So I know there's not much time for questions, but I'm happy to stick around for a few minutes after if other folks want to.
That was really interesting, Daniel. I wish we had talked before we started so I could have correctly identified what your topic was going to be rather than working from Sophie's notes, but that was really fascinating.
I see there's one question in here. Do justices always vote along their party lines? Definitely not. Definitely not. So, you know, as I mentioned, most cases are not really identifiably partisan, but the cases that make the news usually are. And it is not the case that they always do. And in fact, like Justice Stevens, who I mentioned, you know, a few times here, is a potentially good example. He was appointed by a Republican, but his votes over time especially became increasingly liberal, so that Democrats would have looked upon Justice Stevens with a lot of joy. And so you know, justices shift over time. Harry Blackmun, who wrote the Roe versus Wade opinion, was appointed by Richard Nixon. And so it is certainly not the case that party affiliation is determinative. But I think it is increasingly so because of the way in which individuals get filtered to the Supreme Court. You know, to be nominated, they have to have certain marks on their resume that are increasingly connected with party.
So if you were a betting person, you really can't put too much on the swing court, the percentage, I mean, of who's what, because you don't know really how they're going to vote.
Yeah, on a lot of things, you know. So like, for example, a lot of my work is has to do with race and education, and affirmative action is before the court this term. And I know from what they have written previously which justices are likely to vote which way on that particular case, but you don't really know. And there's all sorts of internal dynamics within the court. You know, sometimes you can't even judge the way they vote as being what they actually think. So for example, right now, if you're Justice Elena Kagan, well, you're in a situation where most of the time you're in a closely contested case, you're going to be in the minority, you're going to be in the dissent. But maybe if you can, you know, create some sort of alliance or communicate with some of the more moderate justices who are still tilting conservative, but are moderate, then maybe you can moderate the outcome a little bit. And so you'll say, okay, I'll vote with you guys on this one if you give me a moderate outcome, as opposed to if you don't give me the moderate outcome, then I definitely won't vote with you. And so, you know, like if someone like Justice Kagan is voting in a particular case, is it because that's what she actually thinks, or is it because she's playing a longer strategic game within the court? And those are the kinds of things that we just never know.
Thank you.
Thank you so much for this interesting.
You're welcome.
Very interesting.
Like it was a conversation between people. It was so interesting. It wasn't that, you know, it wasn't like a school class. You know what I mean? It was. I loved it.
Great. Thank you very much.
Yeah.
Thank you
for coming. I'll tune in again, I hope.
Bess, let me
interesting subject.
Yeah, Bess, in the future, if you could put your face on the screen, not your hair, that would be also very interesting, because we've been looking at your hairdo the whole time.
Oh,
she can't help it. She's so short.
No, not.
Oh,
who are you talking about hair? Who?
Yours, Bess. Your head.
Sure,
That's all we see.
That's all we see on the screen.
We don't see your whole face.
Yeah. I know. I'll have to learn how to do my chair so it would be a little higher.
Get a pillow.
Okay. Have a good day, everybody.
Thanks, everybody.
Thank
the next
so much,
episode will be
Daniel.
Friday, November 4th, and we've got Rachel Feynman, the head of cataloging and collection development librarian at Rhodes College. So I'll hope to see many of you next time. Thanks a lot,
Happy,
Daniel.
healthy.
Thank you.
Yes, Happy
Thank
New
you.
Year,
Thank you.
everybody. Thank y'all.